Will Brieger on the intersection of law, public policy, and legislative advocacy in California. Will Brieger has built a legal career around a question that sits at the center of effective California public policy: how do ambitious policy goals become laws, regulations, and practical outcomes? That question requires more than familiarity with politics. It requires an understanding of statutory language, regulatory authority, litigation risk, administrative processes, stakeholder interests, and the realities of implementation. Brieger's background brings those disciplines together. A graduate of Amherst College and the UC Davis School of Law, Brieger has worked as a legal professional across environmental enforcement, climate and energy policy, legislative advocacy, and government affairs. His experience includes serving as an environmental prosecutor under 3 California attorneys general and working on matters involving renewable energy, air quality, climate policy, fuels, and environmental protection. He has also represented or worked on behalf of public agencies and climate-focused organizations in matters spanning different branches of state government. That combination of legal and policy experience offers a useful perspective on a central challenge facing advocates in Sacramento: good policy intentions are only the beginning. Legal training as a foundation for policy advocacy. California's policy environment is unusually complex. The state routinely addresses questions involving energy markets, environmental regulation, transportation, land use, emissions, technology, consumer interests, and economic development. A proposal that appears straightforward at the conceptual level can become considerably more complicated when translated into legislation. Who has authority to implement it? How will key terms be defined? Which agency will write the regulations? Does the proposal interact with existing statutes? What deadlines are realistic? Who bears the cost? What enforcement mechanisms are available? Could the language create unintended consequences? These are legal questions, but they are also policy questions. For professionals working in legislative advocacy and government affairs, legal training can provide an important analytical framework. Lawyers are trained to examine the meaning and consequences of language, identify competing interpretations, assess risk, distinguish between broad principles and enforceable obligations, and understand how different sources of authority fit together. Those skills become particularly relevant in the California legislature, where a relatively small change in statutory wording can affect how an agency implements a program or how regulated parties understand their obligations. Brieger's career has placed him on multiple sides of that process. His work as an environmental prosecutor required applying laws to real-world conduct. His legislative experience required thinking about how laws should be constructed before they reached that stage. According to his professional biography, the California Attorney General's office sent Brieger to the Capitol, where he worked on civil rights and environmental legislation that became California law. That experience highlights an important distinction in policy advocacy. Understanding what lawmakers want to accomplish is different from understanding how to write a framework capable of accomplishing it. From policy objective to workable law legislation often begins with a broad objective: reduce pollution, accelerate clean energy deployment, protect consumers, improve public health, encourage investment, or establish stronger standards. The difficult work comes next. An effective advocate needs to understand how that objective intersects with existing law and the institutions responsible for carrying it out. A proposal involving California climate policy, for example, can raise questions involving administrative authority, emissions standards, energy infrastructure, technology, market incentives, compliance costs, federal law, and local impacts. That makes regulatory policy inherently multidisciplinary. Legal analysis helps advocates identify what a proposal actually authorizes or requires. Policy analysis asks whether that structure is likely to produce the intended result. Government affairs adds another dimension, determining whether a workable coalition can support the proposal and whether concerns from legislators, agencies, businesses, environmental organizations, communities, and other stakeholders can be addressed. The strongest legislative advocacy therefore depends on translation. An advocate may need to explain technical regulatory language to a legislator, describe political constraints to a client, communicate economic concerns to environmental stakeholders, or turn a complicated policy dispute into a set of concrete options. That work rewards precision. It also rewards credibility. California climate policy as a testing ground. Brieger's professional experience is particularly relevant to climate, clean energy, and environmental policy, areas where California has spent decades developing extensive statutory and regulatory frameworks. His biography describes work involving renewable energy and environmental clients before his government service, followed by environmental prosecution under 3 California attorneys general. He gravitated toward air quality and climate matters and later engaged on energy, fuels, and other climate policy issues while representing public institutions and climate nonprofits. His experience also extended into federal court. His biography notes his participation with attorneys general from other states in an early climate change lawsuit approximately 2 decades ago. Climate policy is a useful illustration of why the intersection of law and government affairs matters. Reducing emissions may be the overarching goal, but implementing that goal can require decisions about regulatory jurisdiction, technology, infrastructure, fuels, investment, timelines, enforcement, incentives, and costs. Policies can affect industries differently, while regulatory decisions can influence investment decisions years into the future. Legal professionals working in this field consequently need to look beyond whether a particular proposal is desirable in principle. They need to understand how it would operate. That means examining what the statutory language permits, which government entity has jurisdiction, how regulations might subsequently be developed, and whether businesses and public institutions can realistically comply. It also means recognizing that environmental and economic considerations are not always separate policy conversations. In clean energy, the success of a public policy objective can depend heavily on whether private investment, infrastructure, technology, and regulatory certainty align with it. Brieger's stated view captures that implementation-focused approach. We know how to do this. Now private enterprise and public leaders need to get it done. The comment reflects a broader issue facing California climate policy. Technical solutions and ambitious targets matter, but execution determines whether policy delivers measurable results. What effective government affairs requires lobbying is sometimes reduced to access or persuasion. In practice, substantive government affairs can demand considerably more. Effective advocates must know the subject well enough to recognize when legislative language creates a problem. They must understand the institutions involved well enough to identify who can address it. And they must communicate clearly enough that people with different priorities can evaluate the issue without becoming specialists themselves. For someone with Brieger's background, legal analysis provides one part of that toolkit. Negotiation provides another. His professional biography points to experience in both courtroom matters and negotiations for renewable energy and environmental clients, as well as legislative work in Sacramento. Those settings require different methods, but they share a basic discipline: understand the interests of the parties, identify where disagreements actually lie, and determine whether there is a practical path forward. That becomes especially important in legislative advocacy because few significant policy questions involve only 2 competing positions. A climate or clean energy proposal might involve state agencies, environmental organizations, utilities, technology providers, manufacturers, labor interests, local governments, investors, consumer groups, and legislators representing very different regions of California. Each stakeholder may approach the same legislative language from a different perspective. The advocate's responsibility is not simply to repeat a preferred position. Effective policy advocacy requires identifying which concerns are substantive, which can be resolved through drafting or implementation changes, and which reflect fundamental disagreements that policymakers must ultimately decide. Credibility depends on knowing the details. Government affairs are built on relationships, but durable professional credibility depends on substance. For legal professionals operating in the policy arena, that means being able to explain both the purpose of a proposal and its mechanics. An advocate should know what existing law says, how the proposed language changes it, which agency would administer the policy, and where practical difficulties may emerge. The same standard applies when communicating with clients. A business affected by California regulatory policy may want a simple answer about what a bill means. Often, there is no simple answer. Legislation can change through committee amendments, negotiations, budget decisions, agency interpretation, and subsequent rulemaking. A credible advisor must be able to distinguish what is known from what remains uncertain. That is one reason legal experience can be valuable in government affairs. Legal analysis trains professionals to work with ambiguity without ignoring it. It encourages close attention to definitions, authority, precedent, procedure, and consequences. Brieger's experience across litigation, environmental enforcement, legislative work, and climate policy gives him a professional foundation for approaching public policy questions through that lens. His career has involved not just policy objectives but the institutions and legal mechanisms through which those objectives are pursued. The growing importance of cross-disciplinary advocacy. California's biggest policy questions increasingly resist narrow specialization. Climate policy intersects with energy, transportation, housing, infrastructure, technology, agriculture, finance, and economic competitiveness. Clean energy deployment can raise environmental questions alongside permitting and investment issues. Regulatory decisions can affect both public objectives and private capital. That environment creates a need for advocates who can move between disciplines without losing sight of the details. For Brieger, the intersection of law, California public policy, government affairs, and legislative advocacy is a natural extension of a career spent working with the mechanisms of government. The value of that experience is not simply knowing how a bill moves through Sacramento. It is understanding what happens before, during, and after that process. How policy goals are translated into legal language, how competing interests shape proposals, how regulatory agencies turn statutes into rules, and how those rules ultimately affect institutions, businesses, communities, and the public. California will continue to debate ambitious policies, particularly in climate, clean energy, and environmental regulation. The harder question will remain implementation. That is where legal analysis and policy advocacy increasingly meet, and where professionals who understand both the objectives of government and the mechanics of law can make their most useful contribution.